Have joined. Welcome everybody to this session on digital propaganda for war, an issue which unfortunately keeps being extremely timely. So we will discuss a number of legal questions primarily, but also some strategic questions around advocacy for civil society on this topic today. My name is Chantal Joris. I'm the acting head of law and policy at Article 19, a freedom of expression organization who has been working for quite a while now on questions around freedom of expression in armed conflicts, questions around information threats and propaganda for war as well. So what we will discuss today again is questions around different forms of war propaganda, which have obviously been used for a long time by conflict parties, and I suppose in its core the level of deception or some of the tactics or the intended effects might not have changed that much. But what is true that with the evolving technologies, with how information is disseminated during armed conflict has changed, that also impacts some of the tactics, level of sophistication, and just the ways in which propaganda during armed conflicts is disseminated. We will have a bit of a legal discussion today because I have the privilege to be joined by three fantastic lawyers. Perhaps just at the outset, to mention briefly that there are different forms of propaganda during war. Not all of them are prohibited per se, but we have restrictions based on human rights law, humanitarian law, international criminal law, which all need to be taken into account. We will, I suppose, touch maybe upon these other forms very briefly, but the focus will be on one specific type of war propaganda, namely propaganda for war, as specifically mentioned in Article 20, paragraph 1 of the International Covenant on Civil and Political Rights, which, despite of the obvious relevance of its content and what it prohibits, has been to some extent underexplored and underutilized. So what we want to do today is discuss some of the gaps in this provision, some of the opportunities that there could be in sort of activating it a bit more, the relevance of the provision also for private stakeholders, in particular social media companies, and how we can advocate for its activation, or how we should think about this, also keeping in mind that we always want to be protective of the right to freedom of expression, and that notions like propaganda are notoriously vast. So with that, I'm going to introduce our three speakers. First, we have my colleague Maxim Popovic, who is a senior legal officer at Article 19. He leads the law and policy work on freedom of expression in Europe and Central Asia. And substantively speaking, his work focuses on human rights-based responses to information threats, such as disinformation, or, as we will discuss today, propaganda for war, as well as hate speech, defamation issues, media regulation. We also have with us Ayman Sagdoudi. He is the MENA Senior Policy Counsel at Access Now, an organization that most of you will know that defends the digital rights of people and communities at risk. Ayman specifically works on legal and policy issues with a focus on platform regulation, cyber crimes, media regulations, and is really an expert in freedom of expression issues more broadly. Finally, last but not least, we have Tatiana Avdieyeva from Digital Security Lab Ukraine, an organization which addresses digital security concerns of human rights defenders and organizations in Ukraine, but which also does much broader policy and legal work at the intersection of human rights and digital. Tatiana is a senior legal counsel with the SLU, and she focuses specifically on various issues across digital rights, privacy, artificial intelligence, and state surveillance. Very briefly on the structure of the session, I've got 2 rounds of questions to our panelists, and then there will be approximately, we're good in time, we started on time, so there should be approximately 15 minutes or so for questions, for Q&As. There is a chat feature, I've been told, and there is also a Q&A feature specifically. So I will check both at the end, and you can add your questions or comments that you would like to be discussed in any of those. I was also told to say that if you need translation into Arabic, there is also a link in the chat for that. And with that, let's start with a substantive discussion. So, Max, if I can start with you, can you give us a bit of a brief overview of the state of international law and particularly the ICCPR? What does Article 20, Paragraph 1 say about this prohibition on propaganda for war? And if you can talk a bit about sort of main legal gaps, how is it different or similar to the more well-known prohibition of incitement in paragraph 2, and why do you think it hasn't been as practically relevant so far? Thank you.
Yes, thank you, Chantal, and welcome the participants. On this question, I mean, the ICCPR very laconically says that any propaganda for war shall be prohibited by law. And it's a very short sentence, which is also very similar, actually, to paragraph 2, where you have a very similar legal formula that says any advocacy of incitement to violence, discrimination, and hostility shall also be prohibited. But there are definitely a lot of things to unpack in this short provision of paragraph 1. In particular, all 3 words used in the provision present quite a lot of legal issues. Right? First, what is meant by war? Because it's not any war that would be covered by this provision. What is meant by propaganda? As you said, it is an inherently problematic legal term that is difficult to define and narrow down. And actually, the preposition for is also very relevant to the legal application of this provision as well. Unlike Article 20, Paragraph 2, which has received extensive interpretation by OHCHR through the Rabat process, and that trickled down into a number of other guidelines developed by various institutions. Indeed, Paragraph 1 hasn't received a similar degree of interpretation, and we have very few authoritative sources. We do have General Comment 11, by the Human Rights Committee. It's quite short, quite dense. I would also say truncated. So they kind of stop in the middle, stop short of explaining the entirety of the article, albeit it's very short. And there are also a couple of cursory mentions in other general comments. And obviously you have the preparatory works to the ICCPR, state practice, and then you have some jurisprudence, but I think we'll discuss jurisprudence a bit later during this session. So in this general comment 11, the Human Rights Committee very specifically addressed the issue, what is meant by war, what kind of war is covered in propaganda for war, and basically linked this term to an act of aggression. To the definition of aggression. I mean, at the time you had the resolution of the General Assembly. By now, this has developed through international criminal law into a more specific list of acts that would be covered by an act of, would be considered to be an act of aggression. And there is also a separate category, which is a bit vague, which the Human Rights Committee said that it would be the breach of the peace contrary to the Charter of the United Nations. So what it means specifically, it would mean that we need an international conflict. So purely internal conflicts, so non-international armed conflicts, would in principle be excluded by the application of this provision. We do need also a specific type of use of force, so not any type of use of force. For example, advocacy for self-defense is clearly excluded, right? Use of force in self-defense is still use of force, but it is not an illegal type of use of force. So in other words, if a state is attacked and there is a campaign to advocate for a call to arms to counteract the aggression, that would not be propaganda for war. So that has a practical application. Also advocacy for the use of force that would be authorized by the Security Council, even though that's non-existent in practice nowadays. But in theory, if you advocate for the use of force that would be authorized by the Security Council, that's also not covered by propaganda for war. And then there is something interesting that the Human Rights Committee also mentioned, that self-determination, advocacy for self-determination would also be excluded from propaganda for war. So especially in post-colonial contexts, again, if you look at the preparatory works to this provision, that would be an exclusion. But then you would have some gray areas here, right? So for example, would advocacy for an invasion of Taiwan by China be covered by this article? It's an interesting legal question, because obviously China would claim that this would be an internal matter, an internal conflict, right? So not covered by this provision that is primarily focused on international conflicts. And yes, in terms of Chinese legal arguments, they would point out Taiwan's non-recognition as a state, Taiwan not being a UN member. But a strong counter-argument to this position would be the fact that there would clearly be an implication of the breach of the peace internationally and international spillover in the Taiwan conflict, considering the agreements that Taiwan has with other states, such as the US, triggering an internationally problematic situation, right? And a so-called internationalized internal conflict, at least, if not an international conflict, which is also an argument that can be made. So that's on war. Maybe I'll stop here, because there are a couple other gray areas here, but I think that's enough on one word. On propaganda, so in this general comment 11, the Human Rights Committee basically said nothing on what propaganda means. They did say that all forms of propaganda are in principle covered, which is not very helpful. I believe that there should be a differentiated approach to different types of propaganda. And if you look at this end of the sentence, the prohibition shall be prohibited, the ICCPR doesn't say, for example, that it needs to be criminalized necessarily, right? So in that sense, it's similar to paragraph 2, where we know that certain types of incitement can be covered by criminal law, can be prosecutable under the ambit of criminal law, and certain types should not rise to that standard. I think a similar approach should be taken to propaganda for war. There needs to be a more narrowly formulated offense of incitement to an act of aggression, so direct and public incitement to an act of aggression, which exists at the level of state practice in many states. So for example, in Germany or in Finland, you have very good provisions in criminal legislation of these countries that narrow down incitement, specific incitement to aggression, with the international definition of an act of aggression. But
just to say maybe one minute or so, and then you will also have a chance later on, but just conscious of time. Thank you.
Yeah, okay. So I'll just say on the preposition, I think on the preposition 4, the key sort of gray area question here is, does this article cover propaganda before the conflict started, or does it also cover propaganda during the conflict, right? And there are two differing positions on this. You will find a position, for example, with the Special Rapporteur on Freedom of Expression that did say in one of her reports, the current rapporteur did say that she believes it only covers propaganda before the armed conflict actually occurs. But then you will find, for example, in the Court of Justice judgment, RT versus Council, RT France versus Council, where the court said that the propaganda that happens during the conflict also is covered, and you will be in a slightly paradoxical situations where you would have two countries, let's say, being in a state of armed conflict because a part of state A is occupied by state B. So in theory, you will have this continuous armed conflict. Let's say, like in Ukraine, Crimea was occupied by Russia since 2014. So Ukraine and Russia were in continuous state of international armed conflict, at least since 2014. Would that mean that Russian propaganda for war before 2022 would not be covered by this article because there was already an international armed conflict? That would be a very paradoxical conclusion. Obviously, the provisions should apply in that situation. So in that sense, this proposition for war should be interpreted as in support of an act of aggression, I think would be a more reasonable interpretation, again, if you look at the preparatory works. And the final point on your sort of last point of how paragraph 2 and paragraph 1 intersect, I would say that we need something similar to the Rabat process that happened with paragraph 2 for paragraph 1, so that there is a complete process of developing specific criteria, specific test of distinguishing between different types of war propaganda and narrowing them down to the more egregious forms of propaganda for war, and specifically incitement to the crime of aggression. And that would not be very different from paragraph 2. And I think the 6 criteria that were developed for incitement would largely be applicable also to the test for paragraph 1. Sorry, I stop here.
No problem. No, I mean, you were setting the scene, and there is a lot of underlying, very complicated questions, as you say. Also, I think even in the case of Palestine, the question of, is it an international armed conflict, non-international, internationalized? Is it a mix? Is a very pertinent one. Also, of course, political questions that play into this. I want to turn to Eamon. Eamon, you wrote an excellent report last year. I believe it was published in December for Access Now, also looking at many of these questions that Max has already laid out. So also, in case you want to add something or comment on something there, I want to give you the chance. But also, I know that you looked specifically at social media companies, at the issue also of online advertising, which is so important and quite specific. So maybe if you can tell us a bit also, you've reviewed the policies of the social media companies. What have you found? Is it relevant to them? Is that the notion that they use? Where are the gaps? Yeah, please. Thank you.
Yeah, thank you, Chantal. Well, there are many gaps, at least 3 gaps when it comes to propaganda for war and online ads. There is a legal gap, a technical gap, and maybe political economy gap. Regarding the first gap, and I fully agree with Max regarding the absence of clear guidance at the international level on what propaganda for war is. And it had an impact on social media companies' policies. We have noticed the absence of reference to the term propaganda for war in the major online platforms' policies. And I can understand that. I mean, as Max said, the term war propaganda for also the temporal scope, whether it could be applied during the armed conflict or only before, all of these legal questions made it a bit hard or difficult for social media company to have a clear guidance or a clear policy on how to deal with propaganda for war. Plus, of course, the online ads bit. And we noticed that instead they rely on a dedicated policy on armed conflict because they don't have. So basically they were relying on fragmented categories like misinformation, hate speech, violent speech. And as a result, content that justifies war, especially when it is indirect or subtle, would fall through the cracks if it doesn't violate any other narrow policies. So sometimes there is overlap between propaganda for war and other internal policies, again, related to hate speech, violent content, or misinformation. But sometimes when it's really like organized campaign or like subtle messages, it's very hard to detect this sort of content. And of course, their mission, I mean, social media companies, their mission is far from being easy, not only because of the absence of sufficient international guidance, but also because questions of who is the aggressor, who is the victim state, tend to be highly contested, but also political. So the second gap, so the first gap is legal. The second gap is more like technical, and it's related to the functioning of the content moderation systems, which focus on assessing individual pieces of content in isolation instead of analyzing different propaganda for war symptoms to be able to reveal the broader narrative or intent behind the campaign. And therefore, it makes harder for social media company also to tackle propaganda for war, because just by focusing only on one single piece of content instead of looking to the bigger picture, whether through the specific social media company or through other media or broadcasts or other channels of communication. So then it makes it for them harder to detect online propaganda for war. And this is why we suggest in our report as like a recommendation to amend their CIB policy, so the coordinated inauthentic behavior policy, by including propaganda for component, because assessing, as I said, a single piece of content may lead to what we call a false negative decision, which means allowing content that should be treated differently and to remain online. And the third gap is more like political economy. It's related to the core business model of social media companies, which is based on content monetization and engagement maximization, and therefore could amplify harmful war narratives. And the financial incentive could weaken their engagement to prevent harm and international law violations, beside, of course, all the political considerations behind their content moderation decision. And here, there are some questions related to political speech, especially when propaganda for war is being disseminated by political leaders. There has been a question whether social media companies should, for example, treat it in a different manner or not. For example, are they able to fact check a statement made by a head of state to spread propaganda for war narrative? Or are they able to ensure at least the same visibility of content that may debunk such statements? And here I would like to mention a quite famous quote from Serhiy Jadan, who is a poet from Ukraine, when he said, "If war can be started by lies, peace can be started by truth." And I find it very relevant in this context, as it shows how important it is to support journalists' work and pluralism, whether online or offline, to combat propaganda for war narratives. So to respond to your question, Chantal, they don't refer to propaganda for war in their policy, and they are doing so little to address this issue.
Thank you so much. And I think, it's one of these issues where a lot of the challenges around the ability to understand context of these automated tools, as you say, the business model of the social media company. So it's issues that exist generally, but that are accentuated, particularly in this context. Tatiana, if I can come to you, I'd be curious to hear your view also in the Ukrainian context. Is this provision being considered relevant, invoked by regulators or authorities, or generally speaking, is that a provision that is talked about much? in Ukraine, and also looking at the level of social media companies beyond perhaps also online advertising. Are there aspects that you think that you've seen that make the digital propaganda for war specifically challenges, or where you think we still need responses, really? Thank you.
Yeah, thank you, Chantal, and thank you for bringing up this topic. I found it particularly relevant nowadays. Just wanted to second what Max have actually finished his speech on, was the discussion regarding the so-called blurred line between how we should interpret propaganda for war notion in terms of the time frame of its applicability. I believe that that was a starting point for the discussion of whether we actually should refer to this concept to justify any kind of martial law restrictions, or we should go through the procedure of kind of extraordinary measures, martial law, and derogations from the human rights obligations under both. So the ICCPR, which is International Covenant on Civil and Political Rights, and the European Convention on Human Rights. And basically, when the full-scale invasion has just started, there were multiple consultations with civil society, with the experts on media law, human rights, digital rights, and in view of actually lack of general practice of application of Article 20 in terms of propaganda for war notion and unpacking this notion, the decision was made in favor of actually just applying martial law restrictions. Also, another problem, and I actually wanted to just to briefly comment on how we should approach this from the perspective of international law. I genuinely like the idea of including incitement to the crime of aggression as a separate notion, similar to incitement to genocide, for example. But I believe we should not narrow down the definition of propaganda for war exclusively to this one. And one of the reasons why is because of the phenomenon of lawfare. And for non-lawyers, lawfare is just in simple words, it is exploitation of legal concepts in order to justify by default illegal behavior. For example, what Russia did in Ukraine, saying that it is not an invasion and it is not an act of aggression, but it is, for example, humanitarian intervention to defend Russian-speaking population. And many instances of similar conduct, which is tried to be justified by various kinds of legal concepts, are often could be at least potentially qualified as propaganda for war in broad terms, in broad understanding, because it creates the context for distribution of this kind of content, but cannot directly be qualified as incitement to the crime of aggression in a sense. So I believe that also was one of the reasons why actually the lack of interpretation of this definition in the general comment on Article 20, but also in practice, led to application of martial law restrictions, and also inclusion of so-called extraordinary measures into different kinds of laws in Ukraine. For example, the law on the media contains a separate chapter that provides for the measures that can be applied exclusively when there is an aggressor state. So as long, for example, as there is a status of aggressor state applicable to some country that is voted by Ukrainian parliament, that the state is recognized as such, then these measures will be applicable. And also indeed the sanctions mechanism. Indeed, whatever criticized it is from the perspective of human rights in terms of the clarity and in terms of basically the limits of how these measures can be qualified and can be seen, still sanctions have been applied quite effectively in terms of identifying the subjects that can pose threat, and also more importantly, even adjusting to how technology evolves. Because that was one of the biggest problems, in a sense, when the legislation was not adapted to what kind of digital threats in particular have been faced by Ukraine. And thus, the mechanisms like sanctions in terms of, from the perspective of international law, they still can be qualified as countermeasures. in a sense. So when such countermeasures have been applied, they were tried at least to be adjusted to how digital threats look like, how artificial intelligence looks like, how online media and fake pages online that are doppelgangering Ukrainian media and foreign media are distributing malicious content and so on. As regards tech platforms, the situation is a little bit tricky because here the actors are divided like in two big groups, like good faith actors, for example, those who themselves approached Ukrainian civil society, the regional organizations and coalitions trying to actually understand the context and react upon the threats that were emerging, and those that did nothing, and even more, they didn't even respond to attempts to contact them from the side of the civil society. And it is a very tricky situation since Ukraine is not yet a part of the European Union and we do not have the mechanisms like Digital Services Act proposes. And in most cases, we do not have the jurisdiction over tech giants, meaning that we cannot effectively enforce any kind of legislation. And I believe that will be the biggest struggle probably in the nearest time, even in case we pass the law that covers the activities of the platforms, that actually forces them to comply with human rights when they provide their services for Ukrainian citizens and in the territory of Ukraine. My biggest concern is the possibility of Ukrainian government, the technical and legal opportunities to actually enforce these laws. And probably one of the things that I wanted to mention that might be interesting to the participants is the ongoing AI race and its impact on how propaganda for war also is shaped and how it is distributed. Apart from the ordinary deepfakes and similar things that are more well known to the community, there's a big struggle with phishing attacks and with similar things when basically the accounts and pages of activists, of famous journalists, of politicians are hacked and then used to distribute this kind of content to the larger audience. So I believe that we should approach this not only from the perspective of content assessment and content evaluation, but also consider institutional and infrastructural things, like Ayman has already mentioned, for example, coordinated and authentic behavior, which is much broader than simply framing or like shaping any kind of idea into the message. It also includes creating accounts, it also includes creating networks, it also includes using various kinds of technology to both facilitate the distribution, but also to hide the identities of the individuals who actually stand behind this kind of behavior. So I believe it's important to ensure that we approach propaganda for war a little bit broader than, for instance, is done with incitement to hostility and hatred in the Rabat Plan of Action, where mostly the content side of the issue is touched upon, but to approach it like in a broader term, especially since we are speaking of digital context and digital dimension of it. I will probably stop here and give floor back to Chantal.
Thank you very much. Just a quick reminder for anyone, if you have a question that you would like to ask, add to the chat and the Q&A. Thanks, Etienne. I think also, as you say, there are certain more sort of conduct-based rather than content-focused behaviors that we should not forget when we think about propaganda for war. Then for me, the question also rises to what extent is such conduct, then covered by freedom of expression as well. So that's like then the other coin of that question, which is something that we are of course concerned with when we think about restrictions based on Article 20. So I want to hand back to Max, and also it goes in the direction of this question. If we think about highlighting the importance of Article 20, if we want to think about how can we activate Article 20, paragraph 1, what should we be wary of for freedom of expression, but also on the international level, are there any human rights committee complaints that have been brought on that basis? Is it operational at all in terms of enforcement or protection, so to speak, or is this really still a bit of a dead letter, at least at the international level?
I think it's not entirely dead, but it has been paralyzed for so long that it's barely alive, I guess. But it can be alive and kicking if certain things are done more robustly at different levels. But to answer more seriously, I think the activation of accountability tracks under Article 20, Paragraph 1 depends on the specific type of obligation that exists under this article. Because we have at least 3 specific state obligations, kind of keeping digital platforms outside, because Tatiana and Ayman already covered this very well. So I'll focus on the state measures, state accountability issues. First, you have an absolute obligation that states and their officials cannot engage in propaganda for war. This is an absolute obligation. It is non-derogatory also. So even in times of emergency, in times of armed conflict, it is prohibited to derogate. So states cannot engage in propaganda for war, period, in any way. Then secondly, there is a positive obligation for states to prohibit by law, as a matter of public policy, propaganda for war. And this can be done through, I think should be done through a series of different measures. So it can be done through the ambit of criminal law for egregious forms of propaganda for war, but also things like media regulation, for example, again, digital services regulation, and so on and so forth. And then thirdly, you have a due diligence obligation for relevant state authorities to, with regard to propaganda for war disseminated by other actors. And that can include resorting to appropriate preventive, protective measures, but also accountability measures. And I think it is primarily in this third segment where we have potentially too expansive or selective application of this provision, and then sort of the classic freedom of expression concerns would arise from that third bit of the obligations. In terms of how it has been activated in different accountability tracks, or how it can be, in terms of state-to-state accountability, there is this theoretical procedure, a mechanism under the Human Rights Committee that would allow an interstate claim. So one state saying that another state is not performing its obligations under the ICCPR. This can concern any provision under the ICCPR, but it's not very effective because it would go through several ad hoc commissions that would have to be created, and ultimately it would only result in sort of a finding of facts by the Human Rights Committee. I don't think it is a very credible track for accountability. I think it's more realistic at this stage that this provision would be activated at state level, at the level of specific states, be it with regard to internal propaganda for war, so the one that happens within the specific jurisdiction of that state by other actors, or externally, for example, if it affects the state or on the basis of universal jurisdiction. Here, there are several sort of obstacles to this. Well, the immediate obstacle is that many states have made reservations and declarations to Article 20, Paragraph 1. Including, states like the US or the UK or Denmark, lots of states in the West, especially, because historically this provision was proposed by the communist bloc and was opposed by at that time, the capitalist bloc. So a lot of these reservations are sort of historical, but it's important to say that a lot of these reservations are to both paragraphs of Article 20. Like, for example, the UK's observation is to the entirety of Article 20, and they say we are not under no obligation to create new legislation either under paragraph 1 or 2, which doesn't mean, by the way, that UK hasn't created legislation under Article 2, but that's a separate question. I think the biggest recent example of how this was activated is this case I mentioned, RT France versus Council at the Court of Justice of the European Union level, where the provision was very directly relied upon And it's telling that the court, this specific court, which is not a human rights court, of course, but this specific court had no EU law to use, right? They could not refer to any specific provision in the Charter of Fundamental Rights. They fell back on the ICCPR in this paragraph 1, and they linked disinformation, statements in support of an ongoing war of Russia against Ukraine and other types of manipulative information techniques that Russia used under the ambit of propaganda for war. So very much in line with what Tatiana and Ayman were saying, that there needs to be an analysis of a narrative rather than an isolated piece of content. You need to look at again, this speaks to the need of having a clear test, right? We need to have a test which would say you need to look at the intent, likelihood, context, content. So I think it would be very, very similar to incitement to violence, discrimination, hostility, obviously with adjustments. So with context, you would be looking at things like history of military conflict and tension between these two states. You would be looking at things like military capabilities to actually commit an act of aggression, history of colonization, diplomatic relations between these two states, political tensions, military alliances, and so on and so forth, right? That would be the context part of that analysis, which to some degree, to give credit to the Court of Justice, they did in the judgment. The decision is, of course, criticized from other standpoints, other freedom of expression standpoints, but I think that's outside the ambit of this discussion here. Propaganda for war was used, and I think the reliance on that provision was in principle justified. Now, in some states, the Human Rights Committee insisted on reversing their reservations and declarations that they have made to the ICCPR, and specifically paragraph 1, successfully. So for example, Finland maintained a reservation to this paragraph for decades, until suddenly in the 2000s they adopted national legislation on propaganda for war, and very good one. It's one of the best provisions I have seen on propaganda for war, very robust, with actually a 6-part test implemented already in the paragraphs of the criminal provision that they adopted. So taking into account the status of the speaker, his or her intent, and so on and so forth. So that was a success, and that's a track that the Human Rights Committee likes to take to convince states. What civil society specifically can do, I think, is first to take principled positions against any propaganda for war that is happening, especially in the state where they work or where they're based. As, for example, a coalition of American NGOs who took such a stance in 2003 and submitted a shadow report on the Bush administration's propaganda for war, justifying the invasion of Iraq. A shadow report to the Human Rights Committee that was submitted to the Human Rights Committee at that stage, and looked at the disinformation, the false statements, the false claims that the Bush administration made from the ambit of this provision. So that is, one example how this provision can be activated. And then at the various levels, I'm cognizant of the time, so maybe one last thing. At the various levels of reviews of specific obligations of states, let's say the UPR review of the implementation of human rights obligations, there is a possibility for civil society and other states to press for the freedom of expression compliant implementation of this provision as well. I want to say a lot more things, but I want to give the floor also to other panelists, so I'll shut up. Thank you.
Thank you. Yeah, I think, just two things to pick up on. On the one hand, I'm curious to see all the, military history between two states, how you feed that into an automated content moderation tool. It's again one of those where I think that makes it very challenging. And also how we need to always think even about international law enforcement, how important the domestic level is, and universal jurisdiction, as you mentioned. Eamon, I want to come again to you. In your report, you also suggested that a framework or a process similar to that of Rabat, which has been mentioned a few times, could be relevant. Maybe for those who are not familiar, if you can very briefly explain what Rabat is and how it has been relevant in the context of incitement and hate speech. And also, if you think about trying to do this process now, what do you see as the main challenges and obstacles?
Thank you for this difficult question. So for hate speech, we have a test, which is the Rabat Plan of Action, which is a UN guiding document. It was prepared after consultation with experts. Article 19, of course, was leading from the civil society side, special rapporteur, etc., etc. And I think this document is very important because at least there is sort of test which can be used by courts, regulator, even civil society sometimes for our work is very useful. And I think it's very important to have a similar process to the Rabat Plan of Action in relation to propaganda for war. So as I said, for hate speech, we have the Rabat Plan, but for propaganda for war, basically we have just a vacuum. As Max mentioned earlier, a lot of questions, gray zones. And I think this creates a sort of paradox, as we have more or less clarity on hate speech than on speech that can amplify hate speech. Because as we know, wars are fertile grounds for hate speech. And I think it's very important to have, again, a similar process. And having a guiding document on paragraph 1, article 20 from the ICCPR would be relevant not only to tackle propaganda for war, but even to protect freedom of expression, because we need to know, like, the boundaries between protected speech and lawful speech. And even this is very useful for social media companies to develop their own policies. And to move forward, 3 steps are needed. First of all, I think we need to clarify and define what propaganda for war is. And of course, in this context, we can have all the legal conversation around the definition of propaganda, war, temporal scope, indirect and direct incitement to war, and other legal issues. And this step is very crucial to ensure consistent enforcement, whether by courts, regulators, or social media companies. The second step is to develop a test with different tiers by taking into consideration the digital reality. And here I'm thinking about new forms of propaganda for war, such as memes, online ads, cartoons, also the use of artificial intelligence, etc. And this sort of guidance could also help social media company, because to tackle propaganda for war in the digital realm, we can't only rely on automated tools. We need also to have a human review. And this is very important because, as you mentioned earlier, with historical context, with political context, etc., etc. So you need to have like human reviewers to be able to assess in a better manner the content. And the third step is to have sort of multi-stakeholder process by including states, expert, online platforms, civil society organization, and others. And this maybe at the moment we are in the wrong time, but at least this could be initiated by civil society organization or even the OACHR, for example. But again, at the same time, I know this might sound a bit ambitious at the moment, given the fact that there are many hurdles, because unlike hate speech, propaganda for war is often state-sponsored content, and hence would probably trigger a political resistance from states who are usually involved in wars. And beside this, there is the geopolitical fragmentation, which also would make consensus around international guiding principles quite difficult. Finally, also we can see maybe some reluctance from social media companies, not only because of the financial impact, but also because we have seen little engagement with the civil society organization on several topics, including human rights and information operations, especially during the last 1.5 years. But at the same time, we need their presence and commitment in such discussion to ensure that digital space respects international law.
Thank you so much, and I agree very much. I think, geopolitically speaking, it's a very tough moment probably to advance any discussions around any progressive interpretation of international law, but also this one being a particularly touchy subject. Tetiana, as we acknowledge that the state of play with propaganda for war is not the easiest one, but we also said that there are overlaps with hate speech, with other types of content, and hence there might be other types of rules that very much can restrict certain types of propaganda for war. And also going back to the universal jurisdiction question, so yeah, picking a bit from different areas of law, where do you see that accountability today for maybe not all types of propaganda but for war, but how can we be creative to still use the available legal tools to seek accountability and protection?
I think like the key here is to distinguish between accountability and protection, actually, because at some instances we can actually exploit the instruments provided by the international law, for example, already mentioned countermeasures and other relevant instruments that allow you to take otherwise illegal steps in order to defend yourself against international wrongful acts. That might be a useful tool actually to think about in terms of developing the counter strategies in order to tackle this kind of illegal content. On the other hand, a more problematic aspect from my perspective is actually bringing accountable both individuals, institutions, and states to justice, because that is entirely politicized matter, and it's very difficult to actually starting from the issue of immunities of the highest state officials that cannot be brought to any kind of legal, like the court of law on the domestic level, but also who cannot be physically brought, for example, to The Hague in order to stand before the ICC, even in case the court has jurisdiction and has already provided the order against such people. So I believe that's the biggest struggle here, that sometimes we can actually try to stop the content from spreading, and we actually can even tackle some patterns of the behavior we are speaking about, both like the indicators of the propaganda for war, hate speech, any kind of illegal incitements like incitement to hostility, incitement to violence, or any other kind of illegal incitement. But more problematic is to actually bring accountable to justice. And by saying this, it raises another problem, that there is no preventative mechanism from the perspective of how criminal law generally works, that sometimes the very punitive function of the law serves also as a preventative function, because those who are committing certain kind of an act will not do that because of the fear of the repercussions. In this case, unfortunately, this doesn't function as well. I believe that one of the potential scenarios where we can think of actually bringing this issue to the table are the talks around Convention on Crimes Against Humanity, since still there is a debate around this topic. There might be a possibility to a little bit, at least slightly, reshape the understanding of how freedom of expression generally interplays with international criminal law, and thus how similar kind of conduct has to be interpreted in the light of international law. Also, I believe a fruitful conversation has happened with the prosecutor's office when they had this public consultation, collected input from various kind of stakeholders. So these kind of avenues, I believe, are at least a nice start of the discussion when influential players start including different kinds of stakeholders, including from the local level, to actually bring certain points to the discussion. And I totally agree with Eamon on the thing that civil society has to be included, but also local communities of different kinds have to be included. For example, journalists, the media, war correspondents, other individuals who constantly on a daily basis work with these issues and who know very practical aspects of what actually happens on the ground, how we can approach it, and what legal struggles exist in this area. For example, where is the gray zone? Max has mentioned at the very beginning of this discussion that, for instance, speech in self-defense is apparently excluded from the scope of propaganda for war. However, Ukrainians have been repeatedly criticized for actually calling to join armed forces, to defend themselves, and so on. So from this perspective, there are also multiple issues that still exist and need to either be legally clarified or need to be explicitly mentioned in any kind of guidance or legal document. And probably the last point from my side, I believe it's truly important to actually think about the infrastructure in terms of ensuring due platform governance and AI governance. With platform governance, it's a little bit trickier in view of kind of the very phenomenon of big tech. Their registration, jurisdictional constraints.
Just 30 seconds, Tatiana, please, because we're almost out of time, and I just want to try to fit in two questions from the chat. Apologies.
Yeah, sure. So with platforms, it's a little bit trickier because of jurisdiction. With AI, I believe it will be a big struggle in the upcoming years because there are lots of startups and technologies enabling and facilitating propaganda for war and similar content. So that's a way to go and to think about, because these things apparently can be done on domestic level. And also we have to think about the technical aspect and technical dimension of it, not speaking exclusively of the legal issues. Thanks, and floor back to you, Chantal.
Thank you so much, and apologies again. I know there's so much to cover. Maybe I will try to merge the two questions that we have, but I think in a sense they touch upon something similar. I think one aspect is around the question of sort of denialism, denial of international law violations, maybe misrepresenting how humanitarian law or international law can be interpreted, and thus again denying the violations have taken place and justifying further military operations. So I don't know if you have any thoughts on that overlap or how to approach it, or if you agree that this is a problem. And then the last point, which I think also does touch upon what you said, Tatiana, and maybe others can come in. So what to do, what can you really do in practice as you wait for the long legal accountability mechanisms to kick in? What can you do in practice to also respond to these more subtle forms of propaganda for war? Yeah, anyone who has any thoughts, conscious that we're almost out of time. Go, Eamon.
I can respond quickly to the second question. I think one of the recommendations is to establish, like we asked online platform to establish a sort of mechanism to securely archive online ads related to conflict. And this would be, of course, very helpful for international courts or investigative bodies to access to this content. But at the same time, it's very important to have sort of mechanism where we can document and archive, like as civil society organization or lawyers or activists, where we can archive these online ads so we can use it later on. So also one of the recommendations is to provide, like, to social media companies to provide a sort of accessible mechanism for documenting and researching online ads.
Any other 30-second thoughts? Thank you, Eamon. Max, yeah, go ahead.
Yeah, so maybe just very quickly on the policies of digital platforms. I mean, incitement to war is the ultimate form of incitement to violence, because war is the ultimate form of violence. So if your policy as a digital platform prohibits incitement to violence, you should absolutely prohibit incitement to war. This is paradoxical. If it's not clear to you, then as a digital platform, then you should develop an internal guideline for yourself and make it clear for yourself, and then apply it consistently, because that's strange. If you incite to violence against 10 people, it's prohibited, but if it's against 1 million people, then it's allowed. That doesn't seem right to me. Thank you.
Thank you so much. I think we really need to wrap up sharp at the hour. Thank you very much. The last comment in the chat, which is also interesting. It's not about denial, but disregard of the law. I think that's a whole different, very interesting conversation, which actors try to use the law to justify what they're doing, misrepresenting it, and the others who just blatantly say, the law is not of my concern, my own morality is, or things along those lines. Thank you very much, Eamon, Tetiana, Max, for the discussion. There's a lot still to unpack. It will remain a live issue for sure. And thank you everyone who joined us today, and we hope for further discussions. Bye.
Bye.
Thank you very much.
Thank you. Bye.